case against Rex Heuermann is long, complicated, and intriguing. It starts in February 2022 with the formation of a multi agency task force established by then Police Commissioner Rodney Harrison. It was meant to reinvigorate the investigation into the Gilgo Beach murders. The task force included members of the Suffolk County Police Department, the FBI, and the New York State Police. District Attorney Ray Tierney has gone on record in several interviews to state within 6 weeks of the inception of this task force, they keyed in on a suspect, an architect practicing in Manhattan who lived in Massapequa Park, Rex Harriman, currently age 61. Originally arrested in July of 2023 for three of the Gilgo Four first discovered bodies: Megan Waterman, Amber Costello, and Melissa Bartholomew. With additional investigation and continued examining of the evidence, January 2024 led to the addition of Maureen Brainard Barnes. June 2024, he faced new charges for Jessica Taylor and Sandra Costello. Notably, the Costello case brings the age of these murders all the way back to 1993, expanding the period of time that this alleged Long Island serial killer had moved in the area. In December of 2024, Harriman was indicted for the 2000 murder of Valerie Mack, bringing the total number of victims he's currently accused of to 7. On January 29th of this year, Rex Harriman, our accused serial killer, appeared in the Suffolk County Court with his attorney, Michael Brown, for what was to be a routine pretrial hearing. Our district attorney, Ray Tierney, also was in attendance with several members of the prosecution team. The session focused on two primary motions brought earlier by the defense, one of them formally answered by the prosecution, the other one pending. The first motion addresses the defense's desire to have 5 separate trials for these 7 murders. They would like the first trial to be with the first set of charges: Amber Costello, Megan Waterman, and Melissa Bartholomew, and then follow forth with the other 4 as they were charged separately. Now, they do not even want Sandra Costello and Jessica Taylor, although charged on the same superseding indictment, to be the same trial, because they say the time frames and the methods and all are different. But there's evidence to come, in contrary to that. The DNA attorney has actually opposed separate trials. The prosecution would like to have it all done together. After all, it is their opinion that this is a serial killer, that this is what he does. And we have seen other trials in the past for serial killers where, although it could appear, as the defense states, prejudicial to put them all together, meaning that it would be just like a cumulative effect of guilt automatically in the eyes of the jury. And I can understand that that can be quite prejudicial. Oh, he did it once. I see a lot of evidence there. So perhaps he did it on this one and this one, even though the evidence may not be as strong. Linking them all together does actually show a bigger pattern and more of a probability of guilt. But in order to get a fair trial, that might not always be the best way. Prosecution is arguing that, well, it should be tried together. And one of their key pieces of information in regards to backing up that theory is the discovery of what they call the blueprint for his method and what he was out there doing as a serial killer. In other words, his map, his methodology, his plan on how to be the best serial killer. Now, Rex Heuermann took detailed notes and made detailed plans. He's a very serious person. There was plenty on his computer devices that actually was not in his favor after the searches of his home, and this was discovered. This kind of leads to the serial killer theory here. This is not a like one. We're not charging him for one murder. He, the prosecution believes, he is responsible for multiples of murder, and they are looking for evidence to tie him to others. Now, this blueprint had all kinds of information, problems, supplies. He listed names, he listed sites, he listed prep, pre prep, post event, things that happened. He did his methods of doing recon reports, video cameras, how to take down or pick up the actual intended. Okay. He made notes on every kill, it looks like. He documented what went right, what went wrong, what he could do better. He talked about body prep, disposing of the following as far as everything that he used, tools and devices, what he wore, anything he touched. He also made lists of things to remember, made himself little notes on what to do next time. All of this leads to the idea that his intent, his state of mind, his proclivity was to be a serial killer. He had multiple sources of information on prior serial killers and articles. He kept information on all of these cases. It all leads to the fact that maybe they should be tried together, since that is the actual crime. Additional information of the actual crime, that he's a serial killer, not responsible for just one murder with evidence, but a culmination of evidence that points to the fact that this was something he intended to do on a regular basis and did. Now, the judge gets to decide whether these cases get tried together or not, and he needs to balance it fairly between the rights of the defendant to a fair and non prejudicial trial and the rights of the prosecution to present the case as to what it actually is. Now, there's history in other states across our country where serial killers have been prosecuted together. Their crimes, not individually for one murder or the other, but laying them out together. But then there's also been judges who have actually ordered that the trials need to be separate. So we will see what our judge, Judge Maze, has to say about this, but we're going to have to wait for his orders because he made no decision on January 29th. The second motion is a little more complicated. There is testing that is being used by the prosecution team in this case from Astria Labs in California, and it is a type of whole genome typing. It is used for samples, especially hair samples that do not have a root. It's nuclear DNA testing. It's in a California based lab, which, to its credit, has been used in the medical community and scientific community for years. However, it is new technology, new type of testing done in forensics. And the defense is upset because it's never been used in the state of New York in a court. However, I will note that there was a case in California where multiple murders or homeless victims, that it was used against the defendant successfully in the court, and that happened in January of 2024. So it is new to the legal system. It is not new, however, to the scientific and medical community. It's been used for decades, and I mean decades, okay? It is used because it can be used on degraded samples. In this case, the samples being years old, murders from 1993, 2010, 2000. These are all very old samples of evidence, very old evidence when the bodies were discovered that they had. They found multiple hairs. The defense wants all of the DNA testing tossed out that was done by this laboratory. It wants it tossed out, stating that it's unfounded. Michael Brown had actually even called it magic science in one part. I could go into great details about the type of testing, but basically for the facts of the case, what we need to know is that most of the testing was backed up by mitochondrial DNA testing performed by another external laboratory that is accepted in the state of New York and used regularly, routinely, even if the defense wins the motion to not have the evidence be able to be presented into the court. There is backup testing on the DNA evidence, mitochondrial DNA testing that will be submitted into the court, making the DNA evidence still very prominent in this case. I mean, this is the linchpin of tying everything all together. Now, I have a table here of all of the DNA evidence that they've reported to date. Now, this case is very difficult to get hard records on. It's not open, but the DA has actually put several of the indictments out for us to read. And this table was part of it, saying what evidence was attributed to each of the victims, where it was located, and what testing was done. And I have added to that when they were actually charged. We have actually evidence, DNA evidence for all 7 victims. DA Tierney argues profusely that this evidence should stay in because it's not new. The defense's motion clearly states that it's not been used in this court before and that it needs to come under scrutiny. So the defense is actually calling for a Fry hearing. Now, a Fry hearing is very similar to a Dauber hearing, just a different case for the title of it. Dauber, Lanigan, Fry hearing, they all basically are going to examine the evidence or expert. And at that hearing, we will hear our oral arguments from both sides. And we will hear, hopefully, from Astria Labs, the co founder, Richard Ed Green. And if you go to the Astria website, you can actually find out more about this type of whole genome typing that was done. They are key in the market. He's the co founder there. He's quite the scientific guy. He's credentialed, and I can imagine he may be one coming in to testify for the prosecution in regards to the use of this technology. Now, I'm going to list below the post press hearing statements made by both the defense and the prosecution on January 29th. Michael Brown, who came forward, and he's quite adamant that Rex Heuermann will not get a fair trial if all of the cases are presented as one. It would be too prejudicial to his client, and it would give him like a cumulative effect of guilt that would be biased. He also referred to the Astria DNA testing as magic rather than science. Says it has no place in the court. It's never been used. He's trying to say it's junk science, so to speak. DA Ray Tierney, of course, he's pushing back, and he's going to be putting in a brief in regards to the trials being held together. He actually wants them held together. It's more efficient. It's better laying out of the DNA evidence in the investigation, some of the same testimony over and over in how they tracked down Rex Harriman, etc. Would it's going to be more cost effective, better laying out of the criminal, and then he does have the blueprint on being a serial killer and the intention to do this to multiple victims at the time, leading it as a modus operandi kind of thing with commonality. We've got the mode that the bodies, all of the women were strangled, all of the women were sex workers. He stalked them, lured them in. Similarly, the killing method and the disposing of the bodies, all very similar. Put that together with the blueprint of him actually planning it all out. Well, why shouldn't they be tried together? They are very, very similar. What is against that is actually the timing. 1993 all the way up to 2013. That's a lot of time. And that could go against him because one of the things about trying things that are similar together is the timing, also the method, okay, and the crime itself. Now, we know the crime itself is actually similar, if not identical. Murder, okay. The actual modus operandi, or how it was done, the methodology, now with the blueprint, identical, well planned out and changed, only slightly changed from case to case after reviewing what happened during the crime. I look forward to hearing what is in the brief the DA attorney provides to give to George Mose some reasons to keep these all linked together. I do hope that that will be public, and if it is, we'll be discussing it. In the meantime, he's also already prepared to go against having the DNA testing omitted from evidence. He absolutely is backing up this lab. He thinks this is the cutting edge of the next generation of DNA testing, that it has been used successfully for decades in other industries, and why not in a court? I mean, in regards to cold case solving, being able to test deteriorating DNA or rootless hair DNA that hasn't been able to be tested to such sufficiency prior is a gold mine for cold case solving. I mean, and to have it accepted in the New York court is a big win for them. In the meantime, Judge Mazzi heard both sides, what they had to say, and both the defense and the prosecution agreed to go ahead with the Fry hearing, and Judge Timothy Mazzi scheduled that for this coming February 18th. So we look forward to hearing the results of that. And that concludes our update. In the meantime, if you'd like, share, and subscribe, and please leave a comment if you've enjoyed the content or if there's something else you'd like to see.